Anything else, Mr. Jurkowitz?
As I've stated before, I don't have any county expert witnesses
Right now, with your previous objections to being noted, if you wish to present any further testimony. Gentlemen, we are at 428. Courtroom staff that I'd like to get here, I with the security staff. I think we have a gallery full of people who probably have to get off and get to their business. As I indicated, I'm going to allow the parties to make essentially closing arguments. That's really what's going to happen. You can call it what you want, but I think that's what it's going to be. Council, if we can keep them to about 10 minutes. Mr. Jurkowitz, I understand your basically your equitable approach to this, and I understand just listen to 2.5 hours of testimony. I understand that's probably some of your basis for your equitable plea. I'm not going to tell you what to do in your defense, but you don't need to tell me what Mr. Donahoe said, or Mr. Marsh said, or Mr. Downing said, or Mr. White said. Mr. Jurkowitz, same thing. I've been paying attention to this. But your time is yours. So, Mr. Roach.
Thank you, Your Honor. First, let me address the mandamus request. I think it's pretty simple, straightforward. ARS 16615 is what requires or what tells the counties what they must include in the official returns envelope. And it says, subsection B, the envelope contains the poll list, the tally list, and the stubs of the voted ballots shall contain the official return. Now, the official returns, logically, that makes sense. The tally list should be in the official returns. Those are the official returns. I guess part of your testimony, I moved to for the court's edification, the plaintiff's exhibit number 1, which is the poll worker data vote. But it's already been testified. Pima County.
Hold on one second, Mr. Jurkowitz. Any objection?
Your Honor, I have not had the opportunity to review the exhibit, whether it's what is the actual poll manual from that Mr. Roach's assertion. I haven't had an opportunity to do that.
Okay, well, I'm going to assume Mr. Roach is submitting the accurate original. Mr. Roach, give Mr. Jurkowitz a copy of what you turned in today. And as I think one of your is online. And the whole council referenced it in your pleading, so I went online and looked at it too.
That's different than the Secretary of State's procedure.
Okay, you're right. I stand corrected. But what I'll do is I'm going to admit it for your concerns, and if there's any, if we need to revisit it, just you can file something with me. Go ahead, Mr.
So, again, Your Honor, the things that the county has required in their official poll workers manual does not include the tally list. It does not include the ACU votes, election results report. They basically are not including in the official returns envelope the returns from that precinct. I think that mandamus relief is appropriate. State law requires the county to do this act. They do not do it, and therefore we are asking that they be required to do so. You've heard the rationale why. It's not just because we are picky and want to make sure that things are a certain way just because it became an essential part. And if they had done it in 2006 in the RTA election, we would have had more information about that election. So it is necessary. It's required by law, and it's necessary. So we ask the court order that they do that. Again, the order would be simple. Tell them to instruct their poll workers in 288 precincts with a piece of paper reminding them to put the ACU vote election results report or the tally list into the official returns envelope. And that can be done easily with less than a reading paper. And I believe that's required by law. I don't think there's been any That's the whole point of the checks and balances of our system, and the whole point of a court of equity is that when something so fundamental, I would say your criminal rights to be free of unreasonable search and seizure, habeas corpus, probably the next most important constitutional right that we have is our right to vote, our right to elect who we choose to office, not some nefarious group to come in and pick who is going to be in office. So to say that you don't have the authority because there already have been some rules passed, I think it fails. It has to fail because that's what court systems do. Make sure that the state legislature and the state executives follow the requirements of the state law. The state law says there shall be an active registration and other laws to secure the purity of elections and guard against abuses of the election franchise. Now, the irony of this whole thing is the Secretary of State has already decided, apparently, that this is what should happen, that these precincts, or the early votes should be separated by precincts so that this kind of thing can occur in a way that is logically the best way to make sure that nobody is attacking the systems the way our experts talk about. And then through no knowledge of anybody, apparently, on the Election Integrity Commission, this is done. Secretary of State, Pima County knows about it. Pima County doesn't tell anybody. Pima County asks for an exemption to the requirement that the Secretary of State just made. They're given an exemption without anybody knowing. I think you have to look at that as at least a clue of if somebody's acting in good faith or bad faith. I think you also need to look at the active interference of the election directors, and specifically Brad Nelson, by preventing county races from being included in the hand audits. Why would he do that if you didn't want to have the ability to change an election? Now, I'm not, and again, one of the benefits of this case is I'm not going to say this person has stolen an election. What I presented is that it would be very easy to do, even with the current physical hurdles that Pima County has in place. It would be very easy for a number of different ways and a number of different types of people to modify this election. I had considered, say, calling as a witness, subpoenaing Brad Nelson and asking him this question. If somebody paid you $1 million, would you flip a vote? I would presume you would say no. If somebody paid you $100 million, would you alter an election? I would presume that you would say no. If somebody credibly threatened to hurt your family, would you flip an election? It's an unfair question to ask me, but I would presume you would probably say no. The reason why, in all levels of government, at the NSA, at any time that people want, at banks, at casinos, where people are dealing with something as important as money, they have, you don't just trust people. And I'm not saying anything bad about any particular person, but people are weak. And some people you can find that will flip an election, that would be willing to do it for money or for some other benefit. That can happen. And that's why you need to put in place systems to prevent it. What we're asking for is a system that can prevent that kind of tampering from occurring. And the people who are doing this, or who could potentially be doing this, are somebody in the election department, as was discussed by Mickey Donahoe. These are not things that would be difficult. In addition, not only have we proven that these weaknesses still exist and could be taken advantage of, then you have to ask, well, would it be the interest of, say, people to have designed a backdoor into their system? How much would it be worth to a corporation to be able to sell on a national level influence? And I would say it is worth significant amounts of money if they had done that. We have no way of knowing if they did. No one does. The federal government, the state government, nobody knows, has the ability to know if they made those kind of changes. But it's possible. And until we start putting in procedures that we make sure that that kind of flipping will be detected, we are all and our vote would not count. Arizona Constitution, Article 7, number 12, abuses of elected franchise. I don't think it was necessary, but we have proven in the past, at least, or at least you've heard evidence of what appeared to be a flip election opportunity, so this has occurred, what appeared to be, or at least some problems with the county race, the RTA election in 2006. Keep in mind, if the county, now the people who work in the elections department, who do they work for? The county. And who gets elected by county elections? Members of the board of supervisors. What do you do if you want to make sure that there's a possibility for monkeying around with that system? You make sure when the state passes law, it specifically excludes you in being part of the hand count process. That's what they were successfully able to do. For all those reasons, I would ask that the court order the injunctive relief, and I would have suggestions as to exactly what we could do in terms of to limit the delay that would cause in the system, but I would ask that you rule that injunctive relief is appropriate. The final matter, procedurally, the government has objected to the separation of powers document, or separation of powers argument, saying that you do not have the authority to do it, and then to interfere with election procedures, and then citing Judge Bryson, a fellow member of the Pima County Superior Court bench. What they did not cite was the memorandum decision by the Court of Appeals on the issue of separation of powers that has its memorandum decision, but I believe it's res judicata, and I could cite it to this court because it is involving Pima County elections, where they again claim that separation of powers were not, or the court did not have jurisdiction for separation of powers, and the Court of Appeals found otherwise. So if the court wanted to, that is its memorandum decision 2CA-CB 2010-001. Again, I believe that Rule 20 of the Rules of Appellate Procedure allows citation to a memorandum decision in this particular situation where you have res judicata and the same parties, or at least the same party that's advocating contrary to that memorandum decision. So for all those reasons, I do grant the relief that we request.
Thank you, Mr. Roach. Mr. Jurkowitz.
Your Honor, I would stand in the arguments that you made in relation to this. Even the facts as alleged by the plaintiffs, the remedy is procedures adopted by the state legislature or rules adopted by the Secretary of State election procedure. I think I would disagree with counsel's citations to the memorandum decision. I don't think that's appropriate. But that's not particularly relevant. It is important that their citation is 16615 as far as the tally list. As we explained in our memorandum, in our motion, that's completely inapplicable. The rules in the statute are set up for both electrical and mechanical elections, like we have an optical scan process, and for the old-time leader elections. A lot of those statutory provisions only apply to the mechanical and not the electromechanical elections. This would be one of them. For electromechanical elections, that is governed by the Secretary of State's election procedures. All the procedures, all the items that we included are spelled out on pages 145 through 149. The court can go online and take a look at that. That's what counts. That's what the law is. And Pima County complies.
One thing, let me ask you, and I understand everybody was working on a time crunch. The exhibits to your plea, the July 2, 2010 letter to Ms. Chan and Mr. Nelson. Do you have that handy?
I do.
Okay. The second to last paragraph. Okay. And I want to make sure I'm not missing something. We're talking about, in the second to last paragraph, it's talking about a deviation from the statutory requirements of,
Not the statutory requirement, John. There is no statutory requirements. It's the rule that the Secretary of State has adopted.
okay, but let's go back to 602. Okay. 602 does require a breakdown
copied by the secretary.
Okay. Thank you very much. Witnesses, thank you, ladies and gentlemen. It's good to see everybody here. It's good to see this kind of community participation. Don't let anybody say Americans don't care. We all do. Gentlemen, I'm going to take all this under advisement. I know time is of the essence. I will try to get something to you. I told myself, don't promise anything, and I'll try to get it to you tomorrow, okay? Thanks again, everybody. Thank you.
Judge.